Hey there, and welcome to the Deep Dive. Today we are plunging into a story ripped straight from the headlines, a saga of secret operations, encrypted phones, and alleged organized crime. But this isn't just about the bust. It's a deep dive into the explosive legal war that erupted afterwards, a fight that clawed its way up to Australia's highest court and even dragged Parliament onto the battlefield.
That's right. We're talking about Operation Ironside, a massive covert sting that relied on tapping into communications from the AN0M encrypted app. The evidence gathered was meant to be the silver bullet to lock up alleged criminals, but it ignited a ferocious legal challenge. The defense lawyers threw everything at it, questioning how the evidence was obtained, the validity of the warrants, and even the fundamental laws police relied on.
Our guide for this deep dive is a stack of court documents, the judgments, the arguments, the very heartbeat of this legal showdown. We're going to uncover the technical secrets of AN0M, the intricate legal maneuvers, meet the key players in this drama, and follow the winding path this case took through the Australian court system. Our mission is to peel back the layers on the technical and legal arguments that threaten to completely unravel this mountain of evidence, and to understand how these courtroom clashes escalated into a truly rare confrontation between the judges and the politicians who make the laws.
Okay, let's unpack this dramatic story. It reads like something out of a spy thriller, doesn't it?
It absolutely does. And like many good thrillers, it has an origin story that starts somewhere perhaps a bit unexpected. Not directly with AN0M itself, but with another company called Phantom Secure.
Phantom Secure. They provided those encrypted devices, didn't they? Was that the initial target?
Exactly. This whole saga really kicks off with an operation codenamed Operation Safecracking. It was a joint venture between the organized crime section of the Australian Federal Police, the AFP, and their counterparts in the US, the FBI. Their primary target, Phantom Secure. This was a Canadian company that had carved out a niche providing these heavily encrypted devices, end-to-end encrypted phones, primarily it's alleged, to the organized crime market.
Ah, okay. So a company basically selling secrecy to people who really wanted to stay hidden. And the police, they took action against them.
They did, yeah. In March 2018, Operation Safecracking culminated in significant action being taken against Phantom Secure. The company was effectively shut down, and its owner was arrested. This created a huge disruption in the market for these kinds of devices, essentially leaving, well, a void.
Which sounds like it opened the door for something new to emerge, and that something was AN0M.
That's precisely how AN0M came onto the scene, according to the court documents. As a direct consequence of taking down Phantom Secure, the AFP became aware of a new encrypted communications application and platform that was under development. This was AN0M, and it was being built by someone who had been associated with Phantom Secure. In the court proceedings, this individual is simply referred to as the Confidential Human Source, or the CHS.
Right, the CHS. And the AFP and FBI saw this early stage development as a golden opportunity, I guess.
A critical window, yes, absolutely. They realized AN0M wasn't yet widely distributed or, used by the criminal element in the way Phantom Secure had been. This gave them a chance to get involved from the ground up, essentially. Their objective was to work with the CHS, collaborating to build a specific functionality directly into the AN0M application, a capability that would allow law enforcement to silently access and collect the communications sent and received by users of the platform.
Wow, so this wasn't the traditional wiretap on a phone line. This was about gaining access at the device level as messages were being composed or processed.
That's the core of how the operation is described. They weren't targeting the pipes of the telecommunications network, so to speak. They were collecting the data much closer to the source, right on the AN0M device, facilitated by this capability built into the app itself with the CHS's cooperation.
So they didn't intercept the messages on the network, like in transit. They basically got a copy from the device itself via this built-in secret feature.
That's the fundamental difference, they argued, yeah. It wasn't about listening in on the lines. It was about collecting the data from the endpoint, from the phone itself, before it really went anywhere, thanks to this special function built into the app with the help of the CHS.
And this entire covert undertaking, building and deploying this, Trojan horse platform, was named Operation Ironside.
Correct. Operation Ironside became the overarching name for this sophisticated covert operation involving the AN0M platform. Now, to legally conduct an operation of this scale, involving potential controlled conduct, that's actions that might otherwise technically breach laws, the AFP needed specific authorizations. These were obtained under Part IAB of the Crimes Act 1914, which is the Commonwealth legislation dealing with major controlled operations.
Okay, the MCOs. The court documents mention specific authorizations. Were these standard procedure for something like this?
They were major controlled operation, or MCO authorizations.
Mm.
The sources highlight two primary ones. The first, MCO number 1, was granted by AFP Deputy Commissioner Gahn way back on 25 September 2018. This was clearly a long-term play, as this authorization was varied 11 times over its life and remained in force for a substantial period, actually all the way up until 23 September 2020.
2 years for the first one with multiple changes, and then a second one took its place.
Yes, MCO 02 was granted by AFP Deputy Commissioner McCartney on 25 September 2020. This authorization was also varied 4 times and remained active until 24 June 2021. Both of these authorizations were granted under Section 15GI of the Crimes Act and varied under Sections 15GQ and 15GV of the same Act. These MCOs form the essential legal foundation for the AFP's activities related to the AN0M platform, the development, the deployment, the collection of data, basically providing the framework within which Operation Ironside operated.
So you have law enforcement essentially co-creating their own secret encrypted communication platform, planting it among alleged criminals, all under the cover of these specific legal authorizations. It's quite extraordinary when you lay it out like that.
It's an unprecedented use of technology and legal powers, really turning the tools of secrecy against those who rely on them. And it's precisely this foundational setup, particularly the methods of collecting communications and the validity of those MCO authorizations, that became the absolute focus of the intense legal challenges that followed.
Okay, let's zero in on how Operation Ironside actually intersected with the specific individuals at the heart of this particular court case. We've got 2 defendants, CD and TB, and this incident involving a police visit.
Yes, the sources detail the sequence of events that directly led to the charges against CD and TB and put the AN0M evidence front and center. The prosecution's case against them centers around allegations related to a clandestine drug laboratory found in New South Wales. It's alleged that CD and TB were not only aware of this lab, but actively involved in its activities.
And the incident that triggered everything happened not in NSW, but in South Australia.
That's right. On 12 January 2020, South Australian police officers attended a residential property belonging to a Mr. Wakefield in the suburb of Newton near Adelaide. The police weren't there to search initially, interestingly. They simply informed Mr. Wakefield that they had discovered a clandestine laboratory in NSW. After delivering this, well, quite significant news, the officers left the residence.
Just dropped that bombshell and left. And according to the prosecution, this visit had an immediate and pretty dramatic effect on the AN0M network.
It's alleged to have been the match that lit the fuse, basically. The prosecution argues that this police visit in Adelaide acted as a direct catalyst, triggering a rapid exchange of messages on the AN0M platform. Specifically, communications surged between Mr. Wakefield, CD, and TB. The sources describe the prosecution's interpretation. The police visit made these individuals allegedly realize that their efforts to conceal their criminal activities, particularly those linked to the lab, had potentially failed. And critically, they became concerned that the police might soon return to search Mr. Wakefield's home.
A concern that it turned out was very much warranted.
Precisely. Later that same day, the police did return to Mr. Wakefield's property, this time with a warrant to conduct a search. During this search, tucked away inside a utility vehicle, a ute on the premises, police made a significant discovery: firearms and other items prohibited under South Australian law. These specific items are the basis for the charges CD and TB now face.
And the AN0M messages allegedly tie them directly to these weapons found in the ute.
That's the prosecution's contention and the core of the evidence they wanted to use. The sources highlight specific messages from the AN0M communications that allegedly capture the reaction and the urgency following that initial police visit. For instance, the documents cite a message allegedly sent by CD to TB at 1:08 p.m. that day. It read, "We need ute out today, and we need to use to get warm out there is enough in there to get them both machine gun pistol and sawn off."
Worm. That sounds like classic coded language you'd expect in, well, organized crime communications. And the reference to machine gun pistol and sawn off seems pretty unmistakable given what was actually found.
That's the interpretation presented by the prosecution, yes. They allege this message explicitly refers to the need to move the ute containing the prohibited firearms, machine gun pistol and sawn offs. The sources also note that CD and TV allegedly exchanged messages with other users on AN0M, individuals the prosecution asserts are members or associates of the Comanchero's bikie gang, keeping them informed about the situation and the apparent need to move the vehicle urgently.
And there's another message that seems to confirm the police action at Wakefield's place.
Yes, the sources cite a message allegedly sent by TB at 1:49 p.m. to another AN0M user. Cops just raided AN0 safe house and told the guy we just busted Slug's lab. The prosecution argues this message confirms awareness of the police presence at the safe house in Adelaide, Mr. Wakefield's home, and references the discovery of the NSW lab, allegedly belonging to someone nicknamed Slug. So you have the sequence. Police show up, just to talk. Alarm bells ring on AN0M. Messages fly about needing to move the ute with the guns, using code words. Then police return, properly this time, find the ute and the guns. Those AN0M messages, filled with alleged coded references to criminal activity and contraband, became Exhibit A for the prosecution.
They were absolutely central to the case against CD and TV, and it's the alleged contents of these messages, and critically, how they were obtained via Operation Ironside and AN0M, that propelled this into a major legal battle over admissibility. CD and TV weren't contesting what the messages said, the content, but whether they could legally be shown to a jury at all. Right. And that brings us to the first and arguably most fundamental legal challenge from the defense. Was obtaining the AN0M communications actually an unlawful interception under a key piece of Australian surveillance law?
This was the bedrock of their challenge, specifically addressed in legal questions 1 and 2 before the courts. The defense argued that the method used by the AFP to get the AN0M messages amounted to an interception of communications passing over a telecommunications system. Now, why is that so significant? Because Section 7.1 of the Telecommunications Interception and Access Act 1979, the TIA Act, broadly prohibits such interceptions unless specifically authorized by a warrant under that act.
Okay, so a specific TIA Act warrant is needed for interception.
Exactly. And in Operation Ironside, the AFP used major controlled operation authorizations, as we discussed, and they also used surveillance device warrants and computer access warrants under a different law, the SD Act, but they did not obtain an interception warrant under the TIA Act. The defense argued that without a TIA Act warrant, if what the AFP did was an interception, then the evidence is automatically inadmissible under Section 77 of the TIA Act. It just can't be used.
So the whole case, or at least a huge chunk of it, hinged on whether the AFP's actions using AN0M fit the legal definition of interception under the TIA Act. And the AFP's view was, it didn't.
That was their firm position. They took the considered legal view that their conduct, collecting messages via the AN0M app's built-in capability before they were sent out over the telecommunications network proper, did not constitute interception of communications passing over a telecommunications system as legally defined. Therefore, no TIA Act warrant was sought because they believed it wasn't necessary for this method.
Let's dig into that definition then. What exactly does the TIA Act mean by interception? It sounds simple, but I guess it's not.
Well, the key definition is in Section 7.1. It says, interception consists of listening to or recording, by any means, such a communication in its passage over that telecommunications system without the knowledge of the person making the communication. You see that critical phrase again, passing over that telecommunications system. This is where the technical reality of modern app-based communication slams right into a law written, well, decades ago, really before smartphones and apps as we know them existed.
So it all comes down to when a message starts passing over the system. Does it start when you hit send on the app, or does it start later when it actually leaves the phone?
Exactly. That's the million-dollar question, legally speaking. And to resolve this, the courts needed to understand the technical plumbing of digital communication. They heard detailed evidence from an expert witness, Professor Sinevaratne, who provided a technical description of how these application-based communication systems work.
Okay, how did the professor describe a network? What are the pieces?
He described a telecommunications network as the infrastructure, all the devices and hardware that transports signals from one end device, like a phone, to another. He broke it down into different conceptual layers. There's the underlay network, which is the physical transport layer provided by carriers like Telstra or Optus. Think of the cables, the towers, the routers, the actual pipes. And then there's the overlay network, which consists of the end systems, your mobile phone, a computer, a server, where data originates and eventually rests. In his expert view, these end systems connect to the underlay network, but they don't technically form part of it.
Okay, so my phone is an end system connecting to the Telstra network, the underlay. And the AN0M device is used in Operation Ironside.
These were described precisely as end systems, essentially mini computer systems, smartphones running the Android operating system, AOS, which were specially configured with the AN0M application. The AN0M app itself used the AOS and its interface, its API application programming interface, to access the device's functions like the keyboard, screen, and importantly, the network connection.
So you type a message into the AN0M app on your specially provided phone. What happens next, technically?
Professor Senevirani explained the technical sequence. The device connects to a network like Wi-Fi or cellular to access the internet. It then connects to a central server using a specific protocol, in this case, XMPP, which is actually similar to what apps like WhatsApp use. The message itself, once you type it, is collected by the app, gets encrypted, scrambled with a secret key, and prepared for sending. This encrypted data is then handed off to the device's operating system, the AOS, via a software interface known as a socket. The OS then adds routing information, packages it up, and processes it through various network layers, ultimately preparing it for transmission over the physical network, the underlay as data packets, which are forms of electromagnetic energy or waves.
And the AN0M capability that the police used, it collected the messages at some point during this internal phone process.
That's right. The AN0M capability was designed to collect a copy of the message data from within the AN0M application itself before it was handed off via the socket to the operating system and dispatched over the network. It happened, essentially, between the encryption step and the handoff to the OS.
So the crucial legal question is, when did passing over a telecommunications system begin, according to the TIA Act? Did it begin the instant the user pressed send on the AN0M app while it was still inside the device being processed by the app and getting ready?
That was the core of the defense's primary argument. They pointed to Section 5FA of the TIA Act, which states a communication is taken to start passing over when it is sent or transmitted by the sender. They argued that pressing the send button or activating the send function was the act of sending or transmitting, and this triggered an instantaneous integrated process. They contended that even while the message was still being processed within the mobile device, the end system, which they argued was part of the telecommunication system under the Act's broad definition, it was therefore already passed on over. The collection of the message copied by the AN0M capability at this point, they argued, was the unlawful interception because there was no TIA Act warrant.
Okay, so the defense said, hit send equals transmission started, passing over, began inside the phone. Interception happened inside the device. Illegal evidence. How did the primary judge in the SA Supreme Court see it? Did they buy that argument?
The primary judge disagreed. He focused on the words sent or transmitted in Section 5FA, but read them in the context of the definition of carry in the TIA Act, which implies actual movement or transport across the network infrastructure. He distinguished the act of pressing send, which he saw as initiating the process, from the actual movement over the network. He reasoned that passing over involved the communication moving across the network, not just being processed within the originating device.
So, like, the difference between packing a suitcase and the suitcase actually being on the plane?
That's a decent analogy, yeah. He also looked at other sections like 5FB and 5H, which talk about passage ceasing when the message becomes accessible to the recipient or is delivered. He felt these sections implied that while the sender or the application still had control and was processing the message internally, the passage hadn't started yet. He concluded the message had not commenced passing over while it was still within the AN0M application, being processed internally before dispatch. He even pointed out what he saw as an illogical consequence of the defendant's view. It would mean an interception could occur even if the message never left the phone due to, say, no network connection, which didn't seem to fit the common sense idea of passing over a system.
Okay, so the primary judge said the journey over the network hadn't begun yet. What about the South Australian Court of Appeal? Did they agree?
The Court of Appeal, 2024 SASC 82, ultimately upheld the primary judge's conclusion that it wasn't unlawful interception, so the outcome was the same, but their reasoning was slightly different, a bit more nuanced technically. They were actually more willing to accept the defense's point that the mobile device itself could potentially be considered part of the telecommunications system under the Act.
Oh, but they still found no interception. Why the difference?
Because the crucial point for the Court of Appeal wasn't just the message's physical location inside the phone, but whether it was copied while it was actually passing over. They interpreted Section 5FA, the sent or transmitted part, as clarifying when the passage starts and stops for the purposes of the Act, rather than expanding the core definition of passing over itself. They looked very closely at the technical steps described by Professor Senevirani that happen after you press send, that after checking the connection, performing a handshake with the server using the XMPP protocol, encrypting the data, moving the data through the software layers via that socket to the operating system, getting ready for the physical transmission layer.
And they concluded these steps inside the device before it goes out as a signal weren't the start of passing over.
Precisely. They held that the steps within the mobile device, those preparatory actions before the message actually left the device as energy on the network, did not constitute the commencement of passing over. For the Court of Appeal, the communication did not begin passing over until it had passed through the socket to the operating system, moved down to the physical layer, and was dispatched for transmission as electromagnetic energy across the internet and network infrastructure. The copy obtained by the AN0M capability happened before this point of physical dispatch from the device onto the network.
So they drew the line right at the point the message actually leaves the device as a signal, as electromagnetic energy. That still feels like a very, very technical distinction from a user's perspective. You hit send, you think it's sent.
They acknowledged that directly. They admitted this conclusion might lack intuitive appeal, as you say, to an ordinary person who might feel their communication is private the moment they type it or hit send. However, they argued their interpretation was based on the specific purpose they saw underlying the TIA Act's prohibition on interception.
And what did they say that purpose was exactly? Why draw the line there?
They saw the TIA Act's focus as being narrower than general privacy protection for all communications. Its core purpose, they reasoned, is to protect the integrity of the telecommunications system itself and the privacy of communications while they are moving across that system. It's less concerned, under this specific interpretation, with what happens to a message before it enters the network or after it reaches its immediate destination server or recipient device. Once you accept that potentially limited purpose, they argued, the technical timing of when the copy is made relative to its dispatch onto the network becomes the legally decisive factor. They even found support for this timing distinction in a similar English case, RVA, B, D, and C, where the court also held transmission didn't start the moment send was pressed.
Okay, so the SA courts ultimately ruled that collecting the AN0M messages from within the sending device using the app's capability wasn't an interception passing over a telecommunications system under the TIA Act, because it happened before the message was dispatched onto the network as energy.
Fascinating. What about the argument related to the server that received the messages, the iBot server? Did that count as interception?
Right. The defense had a second string to their interception bow. They claimed that the iBot server, which received copies of the AN0M messages and then stored and retransmitted them to AFP servers for analysis, was itself engaging in interception.
And how did the courts handle that part of the argument? Both the primary judge and the Court of Appeal rejected this argument as well. Their reasoning was based on another section of the TIA Act, Section 5FB, which says the passage of a communication over a telecommunications system ceases when it becomes accessible to the intended recipient. By the time the AN0M communications reached the iBot server, the courts held, their passage over the system had ended because they had become accessible to that server. The iBot server, or the entity operating it, effectively law enforcement in this setup, was considered an intended recipient for that specific leg of the communication path that passed from the AN0M device to the collection server. Therefore, anything done with the messages at the iBot server, like storing or forwarding them, wasn't an interception while passing over the telecommunications system because the passage had already legally ceased.
Okay, so the courts drew a really clear line. TIA Act interception is focused on that specific window of time when a message is actively traveling on the telecommunications network infrastructure. Anything before it leaves the sender's device or after it reaches its immediate destination, like the iBot server in this case, falls outside that window and therefore isn't a prohibited interception under that specific act.
That's the effect of their rulings on the TIA Act challenge, yes. The answer to question 1 was the conduct unlawful interception, with a definitive no. This meant question 2 about inadmissibility based on unlawful interception didn't even need to be answered because the premise failed.
Okay, so the interception argument failed in the SA courts. But beyond that, the defense also challenged the very foundation of Operation Ironside, the legal authorizations themselves, the major controlled operations.
This was their second major line of attack, covered by question 3 in the proceedings. CD&TB argued that the two MCO authorizations, MCO number 1, granted by Deputy Commissioner Gahn, and MCO number 2 by Deputy Commissioner McCartney, were fundamentally invalid. This argument wasn't about what the police did during the operation, but whether the deputy commissioners who signed off on it followed the law correctly when they approved the operation in the first place.
What did the Crimes Act actually require from the authorizing officer in these situations?
Well, Section 15GI2 of the Crimes Act lists the conditions the authorizing officer, a deputy commissioner in this case, must be satisfied of on reasonable grounds before granting an MCO. This includes things like the nature and extent of the criminal activity being targeted, making sure any controlled conduct, like handling illicit goods, can be accounted for, and ensuring no one is improperly induced to commit crimes they wouldn't otherwise commit. It's a checklist of serious considerations.
Right. And what did the written authorization itself, the actual document, have to say according to the law?
That's covered by Section 15GK. It specifies what details must be included in the written MCO authority document, identifying the operation, the type of criminal activity, the authorized people, the nature of the controlled conduct allowed, etc. Importantly, for this argument, Section 15GK does not explicitly require the authority document to state the magic words that the officer was satisfied on reasonable grounds.
Ah, okay. So the defense's argument focused on the exact wording used in the actual MCO documents that were signed. What did they say?
Precisely. The MCO authorization stated that the deputy commissioner was satisfied by information given to me. The defense lawyers seized on this. They argued that this wording, right there on the face of the document, showed that the authorizing officer only required a subjective feeling of satisfaction based on the information presented to them, not the objective standard of being satisfied on reasonable grounds that the law actually mandated in Section 15GI2. They argued this indicated a misunderstanding or misconstruction of this mandatory legal requirement, and that this fundamental error made the entire authorization invalid from the start.
Okay, so they're saying the officer didn't apply the right legal test in their head before signing. How did the prosecution counter this?
The prosecution argued that the wording "satisfied by information given to me" in the authorization didn't show a misconstruction at all. They highlighted, as you noted, that Section 15GK, which dictates the content of the written authority, doesn't require the words "satisfied on reasonable grounds" to be included on the form. Their core argument, though, revolved around the correct interpretation of Section 15GI2. They contended that the officer was required to be subjectively satisfied of the listed matters, yes, but the requirement that the grounds be reasonable was an objective standard imposed by the law itself. It wasn't something the officer necessarily had to subjectively turn their mind to and be satisfied by the reasonableness of their own grounds at the time of granting the warrant.
Right. So the law requires the grounds to be objectively reasonable when looked at later, even if the officer didn't explicitly think, are my grounds reasonable, before feeling satisfied by those grounds.
That's the interpretation the prosecution put forward, and it's quite a subtle legal point. They argued for an objective test for the grounds themselves, distinct from the officer's subjective state of mind in being satisfied by those grounds.
And how did the courts rule on this argument about the MCO validity?
Both the primary judge and the Court of Appeal accepted the prosecution's interpretation here. They agreed with the objective construction of Section 15GI2. They found that the wording "satisfied by information gives to me" in the authorizations was perfectly consistent with Section 15GI2 properly understood. It was sufficient, they held, that the officers were subjectively satisfied of the necessary matters, provided that there were, in fact, objectively reasonable grounds for that satisfaction, a standard that could be assessed later by a court, but didn't require the officer to subjectively second-guess the reasonableness of their own grounds at the precise moment of authorization.
So the defense failed to convince the courts that the deputy commissioners had misunderstood the core legal test for granting the MCOs. The authorizations stood.
That's the conclusion reached by the SA courts. They found the authorizations were not based on a misconstruction of the statutory power. Therefore, this challenge to the MCO's validity was rejected. The courts answered question 3, were the MCO authorizations invalid? With a no for both MCO number 1 and MCO number 2. The MCOs were upheld as valid on this particular ground.
Okay, stepping back from the core interception debate and the MCO validity, the defense also sought to exclude evidence obtained using other types of warrants. These weren't the MCOs, but warrants issued under the Surveillance Devices Act, or SD Act.
Yes, this formed the basis of the arguments around questions 4, 5, and 6 before the courts. The evidence collected via surveillance device warrants and computer access warrants under the Commonwealth SD Act is automatically categorized as protected information under Section 44 of that Act. Generally, this protected information is inadmissible in court proceedings.
Generally inadmissible, so there are exceptions.
There are. The key exception here is if the legal proceeding qualifies as a relevant proceeding under Section 45 of C of the SD Act. If it is a relevant proceeding, then the protected information can be admissible.
And what makes a proceeding a relevant proceeding under the SD Act? How does that work?
A relevant proceeding is defined in Section 6 of the SD Act to include the prosecution of a relevant offense. And here's the crucial link to the federal aspect. A relevant offense includes a state offense that has a federal aspect as defined under Section 4AA of the Australian Federal Police Act 1979, the AFP Act.
Okay, wow, layers within layers. So for the evidence obtained under these SD Act warrants to be admissible against CD and TB, the state charges they faced, the firearms, the criminal organization stuff had to be found to have this federal aspect.
Precisely. The charges against them were state offenses under South Australian law. The critical question became, did these specific state charges have a sufficient connection or hook to Commonwealth matters to satisfy the definition of federal aspect in the AFP Act? If yes, the trial was a relevant proceeding and the SD Act evidence was potentially admissible. If no, it wasn't.
The prosecution presented several different ways these state charges could be seen as having a federal aspect. What were their main arguments?
The prosecution argued for a federal aspect under 3 different subsections of Section 4AA1 of the AFP Act. First, under Section 4A1D, they argued that the investigation of these state offenses was incidental to the AFP's investigation of certain Commonwealth offenses as part of the broader Operation Ironside.
Incidental to what Commonwealth offenses? What was the link?
Well, the MCO authorizations listed specific Commonwealth offenses the AFP was investigating, such as directing or supporting a criminal organization involved in activities like drug trafficking or money laundering, under Sections 390.62 and 390.4 of the Criminal Code, serious money laundering involving $100,000 or more, Section 402.4 Criminal Code, and using telecommunications equipment to commit a serious offense, Section 474.14 Criminal Code. The prosecution contended that investigating the state firearms and criminal organization charges against CD and TB was incidental because gathering information about these state crimes could uncover broader intelligence or leads relevant to the larger Commonwealth investigations into the Comanchero's alleged drug trafficking and money laundering operations nationwide.
So investigating the guns in the Ute might lead to bigger drug busts.
That was the argument. Furthermore, they argued investigating the firearms possession helped determine if the defendants were using AN0M, which is clearly telecommunications equipment, to facilitate serious state offenses like the firearms charges. If they were, that could constitute a separate Commonwealth offense under Section 474.14, making the state investigation directly relevant, or incidental, to proving that Commonwealth crime.
Okay, that's the incidental argument. What was the second way they argued for a federal aspect?
Under Section 4A1C, read together with Section 4AA3, the prosecution argued the conduct constituting the state offenses involved an electronic communication. They pointed directly to the AN0M messages as those electronic communications. They submitted that these messages discussing the need to move the Ute and its contents were the very means by which CD and TB exercised access or control over the utility vehicle and the firearms within it. They linked this to how broadly possession is defined in the South Australian Firearms Act. It includes merely having or exercising access to or control over an item, or even just a place where the item is found.
Right. So the messages discussing the Ute and the guns weren't just evidence about possession, they were the act of exercising control. The conduct itself, linking the communication directly to the offense. And the third argument.
The third pathway was under Section 4A1. Here, the prosecution argued that the specific state offense of participating in a criminal organization under Section 83E1 of the South Australian Criminal Law Consolidation Act 1935, or CLCA, had a federal aspect because this particular state law gave effect to Australia's international obligations under the United Nations Convention Against Transnational Organized Crime, particularly parts of Article 5, which deal with criminalizing participation in organized criminal groups.
Okay, 3 distinct ways the state charges could potentially hook into Commonwealth law: incidental investigation, involvement of electronic communication, or implementing an international convention. How did the defense respond to these arguments?
The defense disputed all 3 pathways, naturally. For the incidental limb, S4A1D, they argued that the investigation of the state offenses wasn't genuinely incidental to the Commonwealth investigations. It was a separate matter. Regarding the electronic communication limb, S4AA1C, they argued the AN0M messages were simply circumstantial evidence of the charged conduct, like possessing the firearms, but weren't the criminal conduct itself. They rejected the idea that just because an offense can be proven using electronic communication means the offense involved an electronic communication in the specific legal sense required by the AFP Act.
So you can use emails to prove fraud, but the fraud itself might be the deceptive act, not the email.
That's the kind of distinction they were drawing, yes. Finally, for the convention limb, S4AA1A, they argue that the South Australian Law on Criminal Organizations, S83E CLCA, didn't match the requirements of the UN Convention closely enough to be said to give effect to it. They pointed to differences, like the convention defining an organized criminal group as requiring 3 or more persons, whereas the SA law includes groups of 2 or more. They also argued there were differences in the required knowledge or intent elements between the SA law and the convention.
So a real battle over the precise interpretation of the federal aspect definition in the AFP Act. How did the SA courts rule on these complex arguments? Which arguments succeeded?
The primary judge and the Court of Appeal made some key distinctions in their findings. They actually rejected the prosecution's argument that the state offenses had a federal aspect simply because the conduct involved in electronic communication, S4AA1C. They agreed with the defense on this point. Being merely circumstantial evidence isn't enough. The electronic communication must be part of the conduct that constitutes the offense itself.
Okay, so that limb failed for the prosecution. What about the argument based on the UN Convention and the criminal organization charge?
On that one, they accepted the prosecution's argument. Under Section 4AA1, they found that the state offense of participating in a criminal organization, that's 83E CLCA, did give effect to Australia's obligations under Article 5 of the UN Convention. They acknowledged the differences pointed out by the defense, like the group size requirement, but found that the state law was still reasonably capable of being considered appropriate and adapted to implement the convention's objectives. So the criminal organization charge did have a federal aspect on this specific ground.
Interesting. And the incidental investigation argument, did that succeed?
Yes, it did. They also accepted the prosecution's argument under Section 4A1D, the incidental limb. The courts agreed with the prosecution that investigating the state firearms and criminal organization offenses was incidental to the AFP's investigation of the specified Commonwealth offenses listed in the MCOs. They accepted the reasoning that this state-level investigation could uncover information relevant to the broader federal drug trafficking and money laundering probes, and, importantly, could assist in investigating the Commonwealth telecommunications offense, 474.14, by determining if AN0M was used to facilitate serious state offenses, like the firearms charges.
So the South Australian courts found that the state offenses had a federal aspect on 2 separate grounds. First, implementing the UN Convention for the criminal organization charge, and second, being incidental to a Commonwealth investigation for both the firearms and criminal organization charges.
That's correct. They specifically answered question 6 regarding the federal aspect via the incidental limb with a yes. This applied to all the relevant counts.
And what about the other federal aspect questions, 4 and 5, which dealt specifically with the convention limb for certain counts and the electronic communication limb? Did they rule definitively on those 2?
Here, the Court of Appeal took what they called a prudential approach. Since they had already found that the state offenses had a federal aspect under Section 4AA1, the incidental limb, that finding was sufficient on its own to make the trial a relevant proceeding under the SD Act, Section 45C. And because the trial was a relevant proceeding, that was enough to make the evidence obtained under the SD Act warrants potentially admissible.
So because one pathway worked, they didn't need to decide if the other pathways also worked.
Exactly. Because they had already found a sufficient ground for admissibility via the incidental limb, it wasn't strictly necessary for them to decide if the offenses also had a federal aspect under the other grounds raised in questions 4 and 5, the convention ground for specific counts or the electronic communication ground. This is a common judicial practice. Courts often try to avoid deciding potentially complex or constitutional questions if they don't absolutely need to in order to resolve the specific case before them. Why rule on 3 difficult questions if answering one settles the immediate issue?
Got it. So the bottom line from the SA courts was the AN0M evidence obtained via SD Act warrants was potentially admissible because the state charges had a federal aspect, at least via the incidental route, making the trial a relevant proceeding where that evidence could be used.
That was the outcome of the SA Court of Appeal's comprehensive decision on all the reserved questions of law that had been sent up to them, a significant win for the prosecution at that stage.
Now, here's where our story takes a truly extraordinary and, frankly, unexpected turn. Just as the case was heading towards the highest court in the land, the High Court of Australia, Parliament decided to step directly into the legal fray.
This is the rare and constitutionally charged moment where the legislative branch, Parliament, and the judicial branch, the courts, came into potential conflict. On 11 December 2024, while CD and TB's case was very much alive and special leave to appeal to the High Court had already been granted, the Commonwealth Parliament enacted a new piece of legislation, the surveillance legislation, Confirmation of Application Act 2024.
The Confirmation Act. And what was the stated purpose of this act? What did it set out to do?
Well, the Act explicitly stated it was intended to confirm the South Australian Court of Appeal's decision, particularly the crucial ruling that the AN0M communications were not unlawful interceptions under the TIA Act.
Confirming a court decision through legislation. That sounds unusual, to say the least. How did the Act actually attempt to achieve this confirmation?
It used very strong, retrospective, and deeming language. Section 5.1 of the Confirmation Act is absolutely central. It states that any information or records obtained under a relevant warrant, which is defined in Section 4 of the Act to include the warrants used for Operation Ironside and AN0M, is taken for all purposes not to have been, and always not to have been, intercepted while passing over a telecommunications system.
Wow. Taken for all purposes not to have been and always not to have been. So, regardless of the technical arguments about hitting send or the signal leaving the device, or what a court might find based on the evidence presented by Professor Sneveratne, this section basically legislates a specific factual and legal outcome. For this specific group of evidence obtained under these warrants, there was no interception under the TIA Act, period, full stop.
That's certainly how its effect is described by those challenging it. It appears to legislate the answer to the very legal question the High Court was about to hear. Section 5.2 follows up by deeming anything done or purportedly done under a relevant warrant to be valid and lawful, specifically removing any invalidity that might arise solely because of Section 5.1's declaration about interception.
And it also deals with whether the evidence can be excluded.
Yes, Section 5.3 tackles admissibility head-on. It states that evidence obtained illegally or improperly solely due to the effect of Section 5.1, i.e., if it would have been an illegal intercept but for Section 5.1 saying it wasn't, is taken not to have been so obtained. This seems designed to prevent courts from using their discretion like under Section 138 of the Uniform Evidence Acts, or the common law public policy discretion, to exclude the evidence simply because it was obtained in a way that Section 5.1 now says is legally deemed not to be an unlawful interception.
It seems like it's trying to shut down the whole interception argument completely. And there were similar provisions aimed at validating the warrants themselves, not just the interception issue.
Yes, Section 6.1 takes a similar approach to the warrants themselves. It states that information or records obtained in reliance or even purported reliance on a relevant warrant is taken for all purposes to have been, and always to have been, obtained under specific valid types of warrants, like the Crimes Act Section 3E warrants or SD Act warrants. The use of purported reliance here is potentially very significant. It suggests the Act aims to validate evidence even if the underlying warrant itself might otherwise have been found defective or invalid for some reason unrelated to interception.
So even if the police only thought they had a good warrant, the evidence is deemed okay?
That's the potential effect of purported reliance, yes. Section 6, 2, and 3 provide corresponding validation and admissibility, deeming provisions mirroring those in Section 5, but linked to this warrant validation aspect in Section 6.
And critically, the Act applies retroactively. It affects cases already in the system.
Absolutely. Section 7 makes it explicit. The Act applies retrospectively and affects even pending legal proceedings, like the High Court appeal CD and TB had already initiated and had special leave granted for.
This is Parliament directly legislating on the core legal issues that were at that very moment being actively argued in the courts, and indeed already scheduled to be heard by the High Court. How did CD and TB, the defendants, respond to this legislative intervention?
Well, this new act completely changed the legal landscape for them. CD and TB didn't just decide to continue with their existing appeal against the SA Court of Appeal's decision on the TIA Act point. They launched entirely new proceedings straight into the High Court's original jurisdiction. This isn't an appeal, it's a fresh case, asking the High Court to exercise its power to rule on constitutional matters directly. These proceedings, listed as A-2025, are a direct constitutional challenge to the validity of Sections 5, 6, and 7 of this new Confirmation Act.
Okay, a direct constitutional challenge. What is their core argument against the Confirmation Act's constitutionality? Why do they say Parliament couldn't do this?
Their central contention is that by enacting these provisions, particularly the deeming provision in Section 5.1, Parliament has unconstitutionally trespassed on judicial power. Under the Australian Constitution, Chapter 3 vests the judicial power of the Commonwealth exclusively in the courts. They argue this act is not a legitimate example of validating legislation, which typically applies new legal consequences to facts as found by the courts.
So they're saying Parliament isn't just changing the law that applies to the facts, it's trying to tell the court what the facts are or what the legal conclusion on the facts must be regarding whether an interception occurred.
Exactly. Their argument is that Section 5.1 is, in effect, a legislative declaration of fact, or a legislative determination of fact. By mandating that the AN0M evidence is taken for all purposes never to have been intercepted, regardless of the technical evidence or legal interpretation, Parliament is compelling a fictional outcome about the nature of the data collection. They argue this prevents the High Court from performing its core judicial function, examining the technical evidence about how the AN0M application worked, interpreting the TIA Act's definition of passing over, and applying the law to determine, based on the facts found, whether an interception occurred. Parliament, they contend, is trying to usurp the court's role and dictate the answer to that crucial question.
And they argue this undermines the role and integrity of the courts themselves.
Yes, that's a key part of their argument. They argue it creates an untenable situation where Parliament has effectively set up two parallel systems for deciding if an unlawful interception happened under the TIA Act. One for cases involving these specific AN0M warrants, where Parliament dictates the answer, no interception, and one for all other surveillance cases, where courts continue to perform their traditional function of finding facts and applying the law. This, they argue, undermines fundamental principles like equality before the law and the institutional integrity of the courts as independent arbiters applying the law to facts without legislative direction on the outcome. They also see the act as specifically targeted legislation designed to make their pending High Court appeal on the interception question futile or redundant.
A very serious constitutional argument. How did the Commonwealth government and the intervening state attorneys general defend the act's constitutionality? What's their side?
They vigorously argued that the act does not exercise judicial power. Their position is that Parliament is acting well within its established legislative authority to regulate the admissibility of evidence in federal courts and in state courts, exercising federal jurisdiction, and also to attach new legal consequences to an existing objective fact. The fact the information or records were obtained under a specific identified type of warrant, a relevant warrant, as defined in the Act.
So the legislative action is about the legal status of evidence obtained under a warrant, not about Parliament deciding whether an intercept actually happened in a technical sense.
That's their key distinction. They portray Section 5.1 as a deeming provision, a common and legitimate legislative tool that takes a specific factual criterion, information obtained under a relevant warrant, and attaches a particular legal consequence to it. It's deemed never to have been intercepted for the purposes of the TIA Act. They argue this is not Parliament declaring or finding facts about AN0M's functionality or the timing of data copying, but rather selecting a category of evidence based on how it was obtained under a specified warrant and applying a new legal rule to its admissibility.
Have there been similar laws upheld before?
They drew parallels to previous High Court cases that upheld laws affecting evidence admissibility, even retrospectively. They pointed to cases like Nicholas v. the Queen, where the High Court upheld a law directing courts to disregard the fact of illegal police conduct when deciding on the admissibility of evidence, and Duncan v. Eisacker, which involved legislation retrospectively changing the legal meaning of corrupt conduct and affecting ongoing proceedings. They argued the Confirmation Act fits within this established line of authority, allowing Parliament to alter legal consequences and admissibility rules. They also stress that the Act doesn't remove all possibilities for discretionary exclusion of evidence, only exclusion based solely on the specific invalidity purportedly cured by the Act, i.e., the interception issue or potential warrant defects covered by S6.
And what about the argument that it targets specific cases?
They maintain that applying the Act to a defined class of evidence or cases, those relying on specific AN0M warrants, is a permissible legislative function, distinct from prohibited ad hominem legislation, specifically targeting named individuals for conviction, like in the famous Sri Lankan case of Lineage. Parliament, they stressed, has the power to enact laws that apply to cases that are already before the courts, even if it changes the likely outcome.
And what about the purported reliance wording in Section 6 regarding the warrants themselves, which the defense also challenged? How did the Commonwealth explain that?
The Commonwealth Solicitor General, Mr. Donahue SC, addressed this during the High Court arguments. He suggested the phrase purported reliance in Section 6.1 is designed to validate evidence even if there might be some technical defect found in the underlying warrant itself later on. The idea is, if information was gathered because officers thought they were acting under a valid warrant, even if that warrant was later found flawed for some reason, Section 6.1 steps in and deems the information to have been validly obtained under the correct type of warrant anyway. This, he argued, is a separate legislative act aimed at curing potential warrant defects, distinct from the interception point covered in Section 5.
So the constitutional challenge boils down to this fundamental disagreement. Is this act a permissible law about how evidence obtained under certain warrants is treated in court, or is it an unconstitutional power grab by Parliament trying to dictate factual findings and legal outcomes in specific, ongoing court cases?
That's the absolute core of the clash. It's a live and, frankly, heated debate playing out right now before the High Court, weighing the legitimate powers of Parliament to make and change laws against the constitutionally protected independence and function of the judiciary.
And both the original appeal about interception and this new constitutional challenge landed before the High Court at the same time recently.
Yes, in a very clear indication of the significance and interconnectedness of these matters, the High Court listed both CD and TB's original appeal against the SA Court of Appeal decision, that's case A24-2024, and their new constitutional challenge to the Confirmation Act, case A2-2025, together. They were heard before the full court of the High Court on May 13 and 14, 2025, for what's called a mention and some initial oral arguments, setting the stage for the full hearing.
Okay, before we get to the procedural summary, maybe let's take a moment to identify the key players, the sort of dramatis personae involved in this complex story, especially those who appeared or were central in the recent High Court proceedings.
Absolutely, it helps to keep track. At the center of the criminal proceedings and now the constitutional challenge are the defendants, now also plaintiffs and appellants, CD and TB. They are the individuals alleged to be members or associates of the Comancheros facing the state charges, critically involving firearms offenses, and participating in a criminal organization based partly on the AN0M evidence. We also have Mr. Wakefield, the resident whose home search triggered the chain of events and the incriminating AN0M messages related to the items seized from the ute on his property.
And on the law enforcement side, the architects of the operation.
We have the Australian Federal Police, AFP, and the United States Federal Bureau of Investigations, FBI, the agencies that jointly conceived and executed Operation Ironside and the preceding Operation Safecracking. The specific MCO authorizations that were challenged were granted by AFP Deputy Commissioner Gowan, MCO number 1, and AFP Deputy Commissioner McCartney, MCO number 2. And of course, the pivotal figure in AN0M's development and collaboration with law enforcement was the confidential human source, CHS, who had links to the earlier Phantom Secure platform.
Who were the experts who helped the courts understand the technology involved?
The key expert providing evidence on the technical aspects, communication systems, networks, and the AN0M app's specific functionality in the South Australian courts was Prof. Sanavratne. The court sources also briefly mention another expert, Mr. Jenkins, in the context of evidence regarding network connection requirements for transmission.
And the judges who have presided over this case as it moved up the system.
The case began before the primary judge in the South Australian Supreme Court, who heard the initial interlocutory challenges regarding admissibility and validity, dismissed them, and then crucially reserved the key questions of law to the Court of Appeal. The Court of Appeal, South Australia, then heard those reserved questions and issued the key judgment, 2024 SASCA 82, upholding the admissibility of the AN0M evidence and validity of the MCOs. Now, the matters are before the High Court of Australia. The specific High Court judges mentioned in the source material as sitting on the bench for the May 2025 mention include Chief Justice Gagler, Justice Gordon, Justice Stewart, and Justice Beach-Jones.
And the lawyers arguing these incredibly high-stakes points in the High Court. It sounds like a gathering of top legal minds.
It certainly is. For CD and TB, the plaintiffs in the constitutional challenge and appellants in the appeal, their counsel mentioned at the High Court listing was Mr. O'Leary, and Mr. Walker presented their oral arguments during that May hearing, forcefully arguing against the Confirmation Act's validity. Representing the Commonwealth, the defendant in the constitutional challenge, and a key party responding to the appeal was the Solicitor General for the Commonwealth, Mr. Donahue, SC.
And there were others intervening, too.
Yes, the Director of Public Prosecutions, SA, sought and was granted leave to intervene in the constitutional matter, A2025, supporting the Commonwealth's position. Counsel for the DPP-SA was present, but not named in the context of presenting submissions in the available sources. Perhaps most significantly, the Attorney General for Western Australia and the Attorney General for Victoria also sought and were granted leave to intervene in the constitutional challenge, throwing their weight behind the Commonwealth and adopting the WAAG's submissions. Mr. Hinton appeared for the WAAG at the initial mention, and the Solicitor General for WA, C.S. Biter, SC, presented oral argument, with Mrs. Alexandra Miller appearing for the Victorian AG and formally adopting the WA position.
That's quite a lineup of legal talent and key government figures involved in this unfolding drama. It really underscores the national significance.
It truly highlights the gravity of the legal and constitutional issues being debated, stretching far beyond just the case of CD and TD.
Okay, let's try to trace the procedural journey of this case then. From the initial operations through the different courts, highlighting the key steps and maybe who was involved legally at each phase, drawing from the sources.
Right, let's map it out. It's a complex path, but we can break it down into phases.
The operation, the incident, and the charges. Before. It all starts, as we said, with Operation Safecracking, the joint AFP-FBI takedown of Phantom Secure. Through this, the AFP identifies the opportunity with AN0M and the CHS. This leads to the decision to develop AN0M as a law enforcement tool, which becomes Operation Ironside. This large-scale covert operation is authorized under Part IAB of the Crimes Act via MCO No. 1, granted by AFP Deputy Commissioner Gowan in September 2018 and later renewed and replaced by MCO No. 2, granted by AFP Deputy Commissioner McCartney in September 2020. These authorizations are varied multiple times over nearly 3 years. Alongside the MCOs, surveillance device warrants and computer access warrants are also obtained under the Commonwealth SD Act to gather evidence. AN0M devices are then covertly distributed, and communications flowing through the platform are collected via the app's built-in capability. The incident. Fast forward to 12 January 2020. South Australian police visit Mr. Wakefield's home, simply informing him about the discovery of a clandestine lab in NSW. This act, according to the prosecution, triggers a flurry of AN0M communications between CD, TD, Mr. Wakefield, and alleged associates. Police return later that same day with the search warrant, search the premises, and seize the utility vehicle containing firearms and other prohibited items. Based significantly on this physical evidence combined with the AN0M communications allegedly linking them to the ute and its contents, CD and TB are subsequently charged with state offenses in South Australia, including firearms offenses and participation in a criminal organization. The prosecution makes clear its intention to use the AN0M messages as key evidence.
Interlocutory challenges in the South Australian Supreme Court. The defense strikes back. Facing these serious charges, CD and TV, represented by their defense counsel, launched pre-trial legal challenges to stop the AN0M evidence from ever reaching a jury. They filed interlocutory applications in the South Australian Supreme Court. FDN 227 specifically challenges the validity of the MCO authorizations, the Gowan and McCartney authorizations. FDN 346 challenges the admissibility of the AN0M communications on multiple grounds, primarily arguing it was unlawful interception under the TIA Act, because no TIA warrant was obtained, and secondarily arguing a lack of a federal aspect for the state offenses under the AFP Act, which would make the evidence gathered under the SD Act warrants inadmissible. The initial ruling. The primary judge in the SA Supreme Court hears extensive arguments on these applications. This involves reviewing the MCO documents, considering legal submissions from both defense counsel and the prosecution, and importantly, hearing the technical expert evidence from Pross and Veronnet about how AN0M worked. After considering all this, the primary judge dismisses both applications. The judge rules that 1. The AN0M communications were not unlawfully intercepted under the TIA Act. 2. The MCO authorizations were valid on the grounds argued by the defense, no misconstruction of the statutory test. And 3. The state offenses did have a federal aspect, at least in the incidental ground, making the SD Act evidence potentially admissible. Questions reserved. However, recognizing the complexity, novelty, and significance of these legal questions, particularly the TIA Act interpretation in the context of modern apps, the primary judge takes the step of reserving specific formal questions of law arising from his decision directly to the South Australian Court of Appeal for a definitive ruling. This happens in September 2023.
The South Australian Court of Appeal hearing and decision. The appeal heard. The South Australian Court of Appeal, SACA, convenes to hear arguments solely on the reserved questions of law. Counsel for CD and TB, effectively acting as appellants on these legal questions, present their case again, focusing on arguing for unlawful interception under the TIA Act, challenging the MCO validity based on misconstruction, and disputing the finding of a federal aspect for the state offenses. Counsel for the prosecution, representing the DPPSA, defend the primary judge's rulings and reasoning. The appeal decision. The SA Court of Appeal delivers its comprehensive judgment, 2024 SASCA 82, in June 2024. They essentially affirm the primary judge's conclusions on all the key reserved questions. They rule definitively at the state appeal level that 1. The AN0M communications were not unlawfully intercepted under the TIA Act, answering question 1, no. 2. The MCOs were not invalid on the basis of misconstruction argued by the defense, answering question 3, no. 3. The state offenses did have a federal aspect under Section 4A(a)(1)(d), the Incidental Investigation Limb, making the SD Act evidence admissible, answering question 6, yes. Applying judicial prudence, they formally declined to rule on the other federal aspect grounds, questions 4 and 5, as question 6 was sufficient to resolve the admissibility issue for the SD Act evidence.
High Court appeal, legislative intervention, and constitutional challenge. High Court appeal sought and granted. Dissatisfied with the SA Court of Appeals decision, particularly on the crucial TIA Act interception point, CD and TB, represented by counsel, including Mr. O'Leary and Mr. Walker, seek special leave to appeal to the High Court of Australia, case number A24-2024. In a significant step, special leave is granted, meaning the High Court agreed the case raised points of law of sufficient public importance to warrant a full hearing. Parliament intervenes. While this appeal is pending, the Commonwealth Parliament enacts the surveillance legislation, Confirmation of Application Act 2024, on 11 December 2024. This act, as we discussed, purports to legislatively confirm the SA Court of Appeals decision regarding non-interception and validate the evidence. Constitutional challenge launched. In direct response to this new act, CD and TB, now as plaintiffs, represented by Mr. Leary and Mr. Walker, initiate new proceedings directly in the High Court's original jurisdiction, case number A2-2025. This case challenges the constitutional validity of Sections 5, 6, and 7 of the Confirmation Act, arguing primarily that Parliament has improperly exercised judicial power. High Court listing, May 2025. In May 2025, both the pending appeal, A24-2024, and the new constitutional challenge, A2-2025, are listed together before the full court of the High Court, before Gageslers C.J., Gordon J., Stewart J., Beach Jones J., for mention and an initial directions argument. Counsel appear for all parties. Mr. Walker for CDTB, Mr. Donahue, SC, for the Commonwealth, plus counsel for the intervening DPP, SA, AGWA, Mr. Hinton, C. S. Biter, SC, and AG Bick, as Alexander Miller. Crucially, the Commonwealth Solicitor General indicates the Commonwealth's intention to seek revocation of the special leave previously granted in the appeal A24-2024, arguing the Confirmation Act now makes that appeal unnecessary or moot. The court directs the parties to agree on timetables for filing submissions for the full hearing of both matters.
Future High Court decisions. The pending decisions. The High Court is yet to hear full arguments and deliver its judgments in both the constitutional challenge, A2025, and the related appeal application to revoke special leave, A24-2024. The outcome. The High Court's rulings will be absolutely critical. They will definitively determine the constitutional validity of the Confirmation Act and therefore the ultimate admissibility of the AN0M evidence for CD and TB. The decisions will likely have profound implications for potentially hundreds of other prosecutions across Australia relying on Operation Ironside evidence, and will set major precedents regarding the boundaries between legislative power and judicial power and the application of surveillance laws in the digital age. This final phase will decide the legal fate of Operation Ironside's digital bounty.
What a complex procedural dance, moving through different courts, raising these fundamental legal questions about old laws and new tech, and ultimately leading to this dramatic confrontation between Parliament and the High Court itself.
It truly is a landmark case study. It tests the limits of technology, the adaptability of surveillance law, and the delicate balance of the separation of powers that underpins our entire legal and political system.
So to recap, what we've really seen is law enforcement using these incredibly innovative, some might say audacious, tactics via Operation Ironside and the AN0M platform. This led directly to the prosecution of hundreds of alleged criminals, including CD and TB in our specific case study. But the real deep dive here, the core of the drama, is the intense, multi-layered legal challenge that questioned every step. From the highly technical definition of interception under a decades-old law to the validity of the high-level authorizations for the operation, and culminating in this extraordinary intervention by Parliament, stepping in to try and effectively settle the key legal debate while it was still actively before the courts.
Absolutely. And the questions raised are profound, going way beyond this one case. How do we apply laws written in, essentially, a pre-digital age to the complex realities of modern encrypted communication applications. What level of precision and foresight is required from law enforcement leaders when authorizing vast covert operations like this? And perhaps most significantly, from a constitutional perspective, can Parliament legitimately legislate in a way that appears to influence or even determine the outcome of specific legal arguments that are currently being heard in the nation's highest court?
It's a case that forces us all, really, to grapple with the rapidly evolving landscape of surveillance and privacy in the digital age. It highlights that inherent tension between the very real need for effective policing to combat serious organized crime and the equally important need to protect fundamental individual rights and legal principles like the separation of powers. And ultimately, it raises the critical question of who has the final say in drawing and redrawing that line, the judges interpreting the laws as they stand, or the politicians who write them, potentially in response to specific cases.
Which really brings us to a final thought, something perhaps for you, the listener, to consider as you reflect on this deep dive. Given the relentless pace of technological change, how can our legal framework remain robust, effective, and fair? How do we continuously adapt it to balance legitimate national security needs and the investigation of serious crime with the fundamental privacy expectations we all have for our digital communications? And perhaps crucially, whose responsibility is it the courts, Parliament, or perhaps a combination to ensure that balance is constantly reevaluated and maintained in this dynamic environment?
A truly fascinating and complex story still unfolding, with potentially huge ramifications. We'll certainly be following the High Court's decisions very closely. Thanks for diving deep into Operation Ironside and its intricate legal aftermath with us today.